Thank you, Nicolaj. I can see you had my slides this morning because actually I think I could just sit down now and Nicolaj has taken all my thunder, but no problem. Thanks, Nicolaj. Thanks for that. Well, I hope you'll bear with me. This is really lawyer's talk. I know it's pretty boring. Not for me, I love it. But because this is my world, and I'm very pleased to see that many of you here. And please put up your hand if it gets too boring, and I'll try to talk a little bit faster and get it over and done with. But what I'm here to talk about is the legal aspects of a startup, and I've tried to summarize the most important things. You've heard a bit of it now, but I'm going to try to make it a little bit more, you know, in blocks, so it may be easier for you to understand it if you have no clue about what Nicolaj has just been talking about. So, yeah.
Will the slides be available?
And that was my next point. The slides will be available for you, of course. Some of them, I think you will send them out later on.
I think it will be sent out tomorrow or something like that.
Tomorrow they'll be sent out, and if you have any questions afterwards, be free to mail me or whatever. If there's something you don't understand in the slides or whatever, you'll get the slides. Some of them I'm going to be quick, some of them going to be wordy, some of them I'm just going to jump, and you can get them tomorrow. So this is my 4 main topics. Why do we need to have a company? Why do we actually need a shareholders agreement? And I'll talk a little bit about this problem about co-founder equity and what happens there, debt equity as we call it as investors. And I will talk about an investment agreement. Is that really needed? Why? And what does it include? And then I will end up having a bit of just comments on warrants, stock options, you know, incentive programs, and the new law that's actually just been agreed upon. This is me. I'm attorney. I have been that for several years now. No commenting on age, please. But I am the lawyer of PreSeed Ventures, and I have actually been with PreSeed Ventures for a very long time. I'm also a partner at Seed Capital, so I have a leg in both those worlds, and I'm very pleased to be able to do that. I have been over 15 years in the venture branch, or whatever you can call it, so I have a lot of transactions in my knapsack. I think I've seen it all, but sometimes I get surprised, and I even today had a long discussion with a company, and I hadn't seen that coming. So you get surprised all the time, and that's what I love about this. But now, why do we need a company? I have been asked a lot of times, why do you as a entrepreneur not just start in the backyard and then start doing your stuff and then roll it out later on? Why do you need a company? And my answer is, it's really easy. Yes, you really need a company. Because otherwise, later on, when you, as we all do, want to get rich and famous and bag it, you need to sell it and part of it. And that's much easier if you have this shell around your idea about your project. So establish a company is important. It's really easy. You can do it either as an IVS for 1 krone. You can do it with 40,000 kroner as an APS, or with 500,000 as an AS. So that's really easy. You can even go in at Erst, the business authority in Denmark, and there is actually a whole, way how you do it. There is a guidance there. There is even standard documents if you want to do this. But please go and do it. Start your company, and then you're good to go. You actually only need to look at your structure, your governance I've put up here, a startup document, an EGM, extraordinary general meeting. You need a board. You don't even need a board if you're an APS or an IVS. You do that if you have an AS. And then you just need a managing director, a CEO of the company. And then you're good to go. And I really do think that this is something you need to do. when we as investors come in, both PreSeed Ventures and Seed, we demand that there is a company. We need to have an APS or an AS, but we usually see IVS as also these 1 krone companies, and then we transfer, and when we put money in, we transfer them to an APS at that time. So just start the company. That would be a good idea. And there is, of course, a little bit of a more problem when you have an APS, because you need to, do the registration that you have to do in Erst in the system there. But it's really not difficult, and that part is not even a lawyer's need to do that. So now I just want to briefly touch upon this because I think it's important. I don't know how many of you know a lot about company law, but I think it's important for you just to know a little bit before you go into the next slide with me. So below the line here, I have put out, this is the, what you can say, company law part. We have a whole set of rules evolving about companies, and the top of that company in the company law is the EGM. That's the top thing in a company. That is the general meeting. That's where the shareholders decide. Then you have a board of directors. They set out the strategy for the company. They employ the management of the company, and they have control of all the valuable things in the company. That's a board. You don't need the board. You can have a management alone, but this is just to set up the structure. Then, so this is the legal part in an act, the Companies Act. Above that, we have the shareholders. That's you, the founders. And you could say, well, we can go ahead, just establish my company, and that would be fine. But you actually, as Nicolaj just mentioned, need an agreement if you are just more than one person in the company. If you have a co-founder, 2 or 3, then you need an agreement to agree on what are you doing with your company. How do we get money to our company? How do we govern our company? Who makes what decision in the company? And that's why I put the line here, because as a lawyer, we speak about what has been agreed and what is in the act. And what has been agreed is normal. If there is a problem up in the top here, we go to the normal court and we have a decision at the normal court. Here, we need to go to an extraordinary general meeting and make the decisions there. So it's important for you to know that there are actually different systems that work together when we are in a startup situation. So what are the 5 main issues to consider when we are making an agreement among founders? And if you are just alone in your company now, and you have your own company and that's it, well, then you probably won't need an agreement with yourselves. Then you can say, well, this is when I get my co-founder on board. Or maybe you are already 3 or 4 together, and you have co-founding already. You need this agreement to be sure of a lot of things. And I will go through these 5 things, which, because Nicolaj only gave me this much time, I actually would love to have spoken to you guys for 3 hours, but guess it's not convenient tonight. But we'll look at the management. I'll look at veto rights. I will look at share classes, preemptive rights, and transfers. And I'll try to do it quick. Well, the only thing I want to say about management when we're here at management is actually that if you have an APS and if you want investors in your company, and now I'm talking from an investor's perspective, it's quite important that you have some kind of governance of your company. We as investors want to help you with rolling out your company, speed on your company, and make it the hockey stick, as you know. So that's why we want to have some kind of influence, and we want to be able to influence, and where we do the influence, it's on the board. It's also when we come with money to your company, but it's usually on the board. At PreSeed Ventures, we always take a board seat when we get on our companies, and the same with seed capital, because that's where we actually do our everyday influence with you guys. And so who appoints and how many? We as investors, we do not want to have control of the board, but we want to be able to appoint at least one, and which is our mandate. Then of course you have as founders 1 or 2 or 3 mandates, but then we think it's very important that we have some industry expert experience into the board, because this is actually where you get the difference in a really good startup and a very slow startup. That's when you have the right people around you in the board. And I know there's been a talk about this earlier on in the year, where Mads has been talking about the right team to be set in the board. But I do think that this is one of the points that's really, really important for you. Also, who appoints the CEO of the company? That is important for us as investors, but it's very important for you as a founder. Who is the CEO? Usually you will say, well, that's me, of course. And when we look into the company, maybe that's right, but that might be right for the first part of the journey, and maybe not later parts of the journey. And you are the real founder, and you of course know exactly where you want to take your company. But just be aware, and I think it's important for you to think about this, saying, well, maybe I'm the right person to go from here to here, but not the next journey. So if you can, say to yourself, well, this is my company, but what I want to do is the best for my company, that maybe not be that you are the right CEO. And we have been, as investors, talking to a lot of founders who were sitting like this thinking, no fucking way I'm not going to, step down as a CEO. But when we got a little bit later on in the journey, they could see, well, I don't have the experience going into sales or whatever. So this is important. And when we go into companies, we of course look at who is the best, who is the very best to run this company at the stage the company is in. And then that takes me actually to the next point, which is veto rights. And we're here. Veto rights, that's a right that you give to one or more investor, or even yourself, of saying yes or no to a decision in your company. Do we buy this daughter company? Do we establish ourselves in the UK? Do we start selling in Germany? And which way are we going? But when you look into veto rights, you have to look at the board, of course. How is that put together? And also you have to look, what are actually the division of the shares here in the company? Who owns what? So usually you as a founder, you own 100% when you start, at least with the co-founders together. And then when you start getting money in your company, you own less of the bigger cake, you own a less part of it. But when all the companies that we invest in, both pre-seed and seed, we are minority investors. So we cannot control at a general meeting when you go up there and take the decision on one way or the other, or at the board. We are not the ones that takes the decision and drives, but we want to have a break. We want as investors to say, we are definitely not spending 2 million to go to Germany when we have not control of our business at home, in our home market. Then we're not spending 2 million in Germany. So we want this break to say, this is the plan we have bought into, and this is the plan we are rolling out. So that's why we really need to have veto rights. But look at the cap table and see, whom do you want to give these veto rights to when you're a founder? And I always say to you as founders, well, we cannot do anything without you, because we are totally in your pocket, but there are things we will say, no, this is not a good idea to spend our money in that way. And then you have to discuss also about among you as founders. When you are maybe 3 founders, Is it okay that 2 of them decides against 1 of them? Or do you really have to sit down and smoke the peace pipe, all 3 of you together, and make the decision together? That's actually a huge discussion among US founders. I think it's important that you also think about, if you have like 10 business angels and 3 investors in, is it necessary that they all have veto rights? All of them? Maybe not. Maybe not. Not all of them. Maybe it's a good idea that we look at who has actually come with the last money, who has actually invested most in this company at the cash level. So they may be, as you know, cash is king. So who has invested the latest at the most value? But as venture companies, we do have standard veto rights. We invest other people's money. At PreSeed Ventures, we have invested during the past years money from the state. And at Seed Capital, we are invested private funds. And that means that we have to take care of other people's money. And I'm not going to go through this, but you'll have it in the slide. These are standard veto rights, and it's actually about, we've decided on a business plan, let's go that way. If you want to change it, we have to agree. The articles, if you have decided that what we're doing is this, you cannot just change it and say, now we're going this way. You cannot just go out and pledge all your shares. You cannot do mergers without us saying yes to it. You cannot loan out all the funds we have granted to you, and you cannot just enter into agreements with you as a founder and lend money so you can buy yourself a house. So there are things, but think of them as breaks. That's what I like to say to them, or an aunt rule or whatever, the boring aunt that says, I'm not going that way. It's not that we're forcing you in a direction. We'll try to push you in a direction, but we cannot force you in a direction. So now I just want to talk a little bit about share classes. What is it? And do we need it? So share classes is when you have your company, you usually just invest in 1 share class. But according to the Companies Act, you have to have different share classes if you have different economic rights on shares. Then you have to have it. You can have different voting rights also on shares. Then you also have to have share classes. I have been, through my 15 years, I have been through a lot of different schemes. In the beginning, we didn't have share classes at all. Then we start using share classes a lot. With veto rights, with liquidation preference, with anti-dilution. I'm going to go back to that in a minute. With all those rights on. And now we are in a valley again, saying, in that sense, saying, well, when we had invested the last 2 years, actually, we've had no share classes. We're investing in the same class as you as founders. So it depends actually on how scarce capital is in the market. We also are flexible, and we kind of find our way in the market. Where are we at this time in the market? So we need them for a liquidation preference. This liquidation preference is one thing Nicolaj already touched upon very briefly. So a liquidation preference is that you, as a founder, you have maybe run your company, you have put all your workforce into the company, but you're also getting money out because you are getting paid a salary every month. We as investors go in and put 2 million on the table for you guys, and then you can run and you take out cash during maybe it's not a big salary you're taking out, maybe it's smaller than you could get if you were on a market, but you get some kind of salary out. But what we do is that we say, okay, when we have invested the 2 million, we want the 2 million back first, and then we divide afterwards according to how much our ownership percentage is in the company. And that's actually the liquidation preference. We have seen it a lot few years ago. I must say now the market has turned a bit, at least in Denmark. We still see it when we go to the US, and when we go there, a lot of the venture funds over there invest only with liquidation preference. And that means actually that you get your money out first, and then you get your share participation out. You can discuss to and fro, is it a good idea, is it a bad idea, is it hurting founders a lot, or is it actually just giving the money back to the investors that have put cool cash on the table. We have seen a lot of situations where there is either a liquidation preference, like you get your money back, or you participate with your ownership. That's called a single dip. Not a double dip, but a single dip, it's called in lawyers' terms. That means you can either put your hand as investor into the bucket and take your money out with a percentage interest on it, or you can take in the other bucket where everybody else takes according to ownership. So that means that it's actually only a downside protection for the investors coming in with the money. I think for an investor's perspective, we like, of course, to have a liquidation preference, but I can also say that at the moment, we're not having it as a standard, but we're seeing it a lot when we go abroad. Anti-dilution, that's actually a provision that protects the latest investment, the latest money you're putting in. So let's say we're investing 2 million and we are really debating the price of your company. You think it's 20 million worth, and when we look at it and compare to other startups, we think it's 5 million. So that's a gap, right? And that gives a lot of problem, and that's about our investment managers, or a few of them here today. You can talk to them about that, and I know you've had a talk about value in companies and how we value companies, but I think it's important to say what this gap can be bridged. We do that every day. We bridge this gap, and we get together, and you have to get a bit up and we have to get a bit down, or the other way around. And then we say, okay, well, fine, we'll go with your value. Let's say it's 17 million, your value of your company. And then we say, but then we need an anti-dilution protection. Because if you go out and get money in half a year and it is at 5 million, then we were right. Because then we have a third person coming in and saying, the value of the company is not more than this. Maybe he's not right, but at least that's another person saying the same as we had said all the time. And that means then the money we invested will be at the same level as the other. Average dilution. And that means that anti-dilution is actually protecting the investor for the rate at which he is investing. I think it's fair to say that we are having this discussion every time. We are not having a standard in our documents in PreSeed and anti-dilution, and I think it's involved throughout the years. Right now there are a lot of business angels coming back into the market, and we think it's wonderful, and that means that this provision is kind of out of documents at the moment. But you can also put a play-to-play in and say to that investor, if you are getting this anti-dilution, you have to invest also in the next round. So then I get something and you have to show that you want to invest again. It's not just you can sit like this and say, okay, but I want my anti-dilution. You have to invest in the next round as well. So the pay-to-play is a mechanism that a lot of investors like as well, because it shows that, you know, if you're a few investors around the table, the ones that are actually wanting and willing to invest in the company will also get the anti-dilution on their shares. So the last slide on this section will be preemption right and share transfers. Preemption rights, that's in Danish forkøbsrettigheder eller fortegningsrettigheder. So preemption rights will be that you have a right as a shareholder already to take the investment that's about to roll out. So let's see you're in the market for raising 5 million, and the investors around the table actually want to come with the 5 million. Then they have a right to do that. They can come with it, because a preemption right, which is normal and standard in companies, is usually used, is part of the terms we as investors invest in you guys, because we want to protect the percentage that we already have. But then of course we have to, you know, put money on the table to protect our right. That's also in the situation of a share transfer. There's a share transfer in the company, and in that sense, we can say, well, we don't want you to sell it to some third party we don't know. Maybe it's Sten Hansen, maybe it's Steinbacher, who knows? But we want to keep the shares in the group that we actually like. Nicolaj said marriage, not a kind of marriage, but we want to keep it in the group we have. So if there is a transfer, we have a right to buy it firstly. And then we also have share transfers. We have a lot of provisions. I don't know what the timing is, but I think it's fair to say that, fine. Lock-up, drag-along, and tag-along are also provisions that you will meet and that you will discuss with your investors. The lock-up is that I would touch upon it because I think it's an important from an investor point of view. And I think also among you as shareholders and founders in your company, it's also an important thing. Because when we invest, we say, we trust you. We're not going to be able to run the company on our own. Because that's you, that's the best to do that. And we need you not to leave the company. We need you to be focused on your company. We need you to have the ownership that we have seen in the cap table you have. So that's why we need a lockup on founders. And maybe Søren will touch upon it later on, of how he looks at that as a founder perspective. But I know that from the other founders, it's also really nice to have a lockup on their co-founders. Drag along, that's that if we want to sell the company, you want to sell the company, because we cannot do it alone as investors. If you want to go out and sell the company, you're not selling the company just over the head of your new investors. That's why we have a drag along, and we say we want to be together with you in a drag along and sell the company. But maybe there are some small shareholders, small aunt, uncle, I don't know, maybe there has been a quarrel with some investors that we want to drag along in the sale because we think it's a really good idea with this sale. Tag along, that's a provision that says if someone is getting out, I can tag along. I can, go out with him, because we don't, when we marry and get into a startup, we want to be with the startup until we exit it together. This is an important issue, co-founders equity. I know that Nicolaj had a bit of a talk about it, but we actually do think that having more than one founder is a very good thing. We see the founders, we like to look at the founders as a team. We like to be able to see that you have diversity in the team and that you have co-founders. So as investing in you guys, it's a really, really good thing that you have founders around the table. But the problem is that some of the founders may be part of the startup from the beginning and then leave. Maybe you said Dubai, maybe they just want to go to Aalborg and do some other stuff. And that means that you have still a person owning a lot of capital or ownership in the company. So why is this a problem? And I've put an example up. This is a real example. I've taken out the name of the company. But here we have a company, and if you look up here in the start, we have the two red founders are the real engineers. They have found us this super idea, and they have started the company. But they needed some sales experience. That was founder 3, and they had him on board. And then they actually found out that they actually needed, because of all this GDPR, they needed a 4th person. They needed a co-founder, new founder, a lawyer, whom they took on board. And then when they set out on the road, you can see this is how the cap table was divided among them in the APS. It looks good. It looks fair and easy. But then there is this little man, red man, running away, because the two top founders, they are actually not part of the venture anymore. So when the investors get in, these two are out. Well, they're not out. They love their company. They're supporting the company, but they have a different job. So here in this real example, we have 52% of what we call debt equity. That means that 52% of this company is owned by founders who are not even on the journey with us. And we think that's a problem, because you are going to find that as a problem as well, as co-founder 3 and you are going to run the company from the very beginning. And it's really, really hard to fund a company like this. And that's why at an exit, as Nicolaj said, you know, these two have been running the company. These two have been have other jobs and or maybe just sitting in the sun. I don't know what. But that means that, is it fair that you have this division of, let's say we exited after this? We don't think it's fair as investors. And I definitely do think that founder 3 and new founder is not thinking it's fair either. So this is a problem you have to look at. And as Nicolaj said, you almost can't, but you have to talk about it. How can you avoid it? You simply have to talk about it. As founders, you need to go in and sit down and say, is this fair? What is a fair deal before we even start the company? Before we even go out and get capital to our company? Because it's much easier at that time to sit down and talk about it. And you need to have, now it's very difficult to see, I'll make sure it's easier to see on the slides you get, but you need to have agreements about it. I put key man clause, vesting scheme, purchase option, and other compensation schemes in. But what is very important is that you sit down and talk about it, and don't be scared, because it's about you, it's about your venture, and how you look at your company, how you take your company on. And as I must say, we talk about it a lot with our founders when we get the cap table and see, so whom are you for are actually working for the company? I have exited a company, and there we had 3 founders, and they were really much into the company, all 3 of them. But when it got a little hard, we didn't have any money at all, the 2 of them left. And the last one, I like to say it's a she, because it is a she, and it was a she kept on going. We supported her from pre-seed and seed. We supported her, and she was the one with the stamina. She was the one that took the company all the way through to a huge exit. So was it fair that when we looked in the cap table and we had to divide the money in the exit, that she got the same as the 2 others? We thought it was not quite fair. So we had, of course, looked at it as investors and said, listen, we'll get you some warrants. We'll try to compensate you the best we can. But of course, we cannot just take money out of our investors' pockets and give it because we think we're sorry for one of the founders. We can't do that because we are handling our investors' money. We are handling money from other people. So this is a very important thing for you founders to have a look at and talk about before you even go on your venture. And you can have it a lot of ways. Keyman clauses saying that if you leave within 1, 2, 3 years, there is a step of how many shares you can keep when you leave the company. Either you yourself leave or you're getting fired from the company, because maybe one of the founders suddenly gets lazy because he gets, I don't know, twins or whatever, and he stays home and takes care of them. I don't know what. But that could be a possibility. Maybe a vesting scheme is right, that you have to earn yourself in as a founder. How much do you work? Then you get more shares. That's also a way to do it. Purchase option, that the other founders can purchase. We see that a lot. And I know that Søren will, in a minute, tell us about the real world in Archii, because they were a lot of founders. He'll talk about it more in a minute. And it could also be another way of compensation. It could be bonuses if you stay on. It could be that you have to divide the shares among you founders, selling agreements and so all that. So there are a lot of ways to do this, but the only thing that's really important is that you talk about it. So let's touch briefly on the investment agreement, because this is very boring legal stuff. But just so that you know it when you see it out there. 5 minutes, thanks. Is it necessary? We think it's necessary. But when you start up in your company with co-founders, you don't really need an investment agreement because you're investing your time in it. But we think it's a good idea to have an investment agreement because you set out what do we invest in, what tranches do we invest? Do we invest in kind, in convertible loans, and also warranties? What kind of guarantees do we need as investors in your company? But I'm not going to go deep into this. If you have any questions on these, they are not as, can you say, I think important as the shareholders agreement will be for you. So I just want to touch about warrants and stock options. Nicolaj just mentioned it, but why do we need an incentive program? Because when you're an entrepreneur, you want to own a bit of the company you're working for. I like that too. I like being able to say that when I do go to work every morning, I do have a bit of a piece of the cake in seed capital. And that's why we need these incentive programs. Also, if you have an incentive program, either warrants or stock options, then you can maybe lower your wage a little bit. Because then you can give this instead and say, well, you get this and look at this, we're going to be here in 5 years and then we're going to be rich, all of us, when we exit. Therefore, we think it's a very, very good idea and we like it. Problem is, it's kind of difficult. 5 main issues you have to look at and remember. You have to see how much of your company do you want to invest in these programs, because it's usually not for you, for founders. You have your shares from the beginning, but it's for all your employees. We usually take out 10% for a stock option scheme. That's very normal, but we see it differently as well. We see it with 15 and we see it with 5%. So we see in this range, and we're prepared as investors to say, well, this is a good idea to have, so we will be diluted with this warrant program you have. And then you have to look at the exercise rate. You have to, are you giving the warrants or the options for your employees because you want them as a compensation for their wage, so they give them at 1 krone? Or is it because they take the value of the company from here to here? So the exercise price will be 100 or 200, and then they have to exercise at 400. But you have to have a look at it and you have to talk with an expert on this. Vesting is also a very important thing. And usually we look at this as that you have to be employed for a year before you even get warrants. And then you have to be employed for even more 2 or 3 years to earn your right to get a part of the company. Dilution is important. This is what we think is very important, is we never give undilutable shares away. We have to be able to dilute the people around the table, including us, of course, as investors. And then termination, what happens when the employee leaves the company, that you have to consider. But seek legal advice. It is a tax issue. I say it's also a tax issue, but it is actually a tax issue from the very beginning. Because there are rules, there is a law, where you can use this law and then you can go over to ligningsloven, which is a special Danish tax regulation. And there you can have a very favorable taxing on these stock options, but then you have to follow certain rules. And I'm not going to go deep into that, but I want to say to you that from the 1st of January next year, there was an idea from the government to create more freedom of contract and to clarify the rules governing stock incentive programs. Because today, not the 1st of January, but today and for the last few years, we had a good leaver and bad leaver situation. That was easy, very easy, I thought. Because if you were a good leaver, that means that you were fired. Then you can take all your stock options with you. If you were a bad leaver, that means that you left the company on your own, saying, bye, I'm not here, then we could take all your stock options from you as a company, from the company side. And that was actually easy, but that's out now. Now we are in a much higher degree of freedom, because now it's only Aftalelovens paragraph 36, the Danish Contract Act, Article 36, that applies. And that has a very rubberish thing, because it actually only says that what is unreasonable and what is not fair and what's against reasonable behavior and all that language, that you cannot agree on. But then you have only the courts to decide on this, and then the agreement which you make with your employees. So it's even more important that you seek advice here, because it is more flexibility that's put into the act now, but the problem is you don't know exactly what is put in the agreement. So there you have to sit down and talk to an expert, and I really always say talk to an expert. And here I always say it's not my table. I say always go to an expert external lawyer, because we at PreSeed Ventures and Seed do not want to take that risk of the tax issue, because it's very much a tax issue, and also about these stock option schemes. I have a checklist to know what do you have to think about. I've tried to share it with you here, and then contact your favorite lawyer. That's actually what I have written in the button. So Nicolaj, what's the timing?
The timing is perfect time.